welcome to the June edition of HR Hot Topics. I'm your host, Jodi Schafer, and today I have a special guest with me, my colleague, Andie Creamer. Andie has joined me on several of these videos in the past, and I just sort of got sick of looking at my own face on these every month. So Andie was here doing some filming for our 30th anniversary party, which is it's coming up as of today when we're filming it. By the time you see this, it will have just passed, and I hope it was a smashing success.
It will be a great
It's going to be really great.
Perfectly fine.
So Andie was here filming for that, and I said, hey, while you're here, why don't you join me for this month's HR Hot Topics? Because I thought what we would do is just have a conversation around a couple of things that we are keeping an eye on and that we think you should be keeping an eye on too. One of them is happening at the federal level. The other two are happening at the state level here in Michigan. So I'll provide a few details on the state level things in a moment. But first, Andie, what are we watching at the federal level? I mean, there's a lot. There's a lot of change, a lot of chaos happening.
Yeah. And I kind of giggle a little bit because I think you promised people no more ESTA.
Yeah.
And no more compliance and law, and here we go.
But that was 3 months ago.
Here we go.
That was 3 months ago.
Okay.
So
the National Labor Relations Board is what we're keeping an eye on because the Trump administration removed a board member from their position because, of course, they want to make it Republican-led. I guess is my assumption that they want to make it Republican-led because it's right now it's Democratically led. The removal of that one individual means they don't have a quorum, so they really can't do anything at this time. The person that was removed has filed a lawsuit for wrongful discharge because the National Labor Relations Act says you can only remove a board member for a cause or malfeasance, neither of which did this individual do. It merely is they want a majority it's political. It's just Republican majority versus Democratic majority. Yep. So last week, the Supreme Court allowed the Trump administration to have an emergency, I don't know what the word is. Well,
they granted an emergency
stay? Is it?
No, it's not a stay.
No.
They said we'll hear the case. We'll kind of bump up the timeline so we can hear the case, but they didn't give a date.
Right.
And in the meantime, between now and when the Supreme Court hears this case, they said Trump's actions could stand.
They said it could stand, that his removal could stand. So what that means now is that the National Labor Relations Board can't do anything. They don't have a quorum, so they can't make any decisions. They can't move forward. So we're just kind of stuck in a holding pattern. And, you know, at the end of 2023, I think is when the National Labor Relations Board made a lot of changes that impacted a lot of ways the employer talks to their employees or the way that they manage their employees. If this change goes through the way I'm sure the Trump administration would like it to, we're going to probably swing the other way. So we'll probably be more pro-employer.
Yeah, that's typically what happens.
And then, you know, not as much freedom as for the employees. So we're keeping an eye on that. There was not a date of when the Supreme Court would actually take this up to make a decision on it. But for now, they've granted emergency approval to have removed this individual from her position.
Yeah, they're going to allow it to stand.
They're going to allow it to stand.
Hear the case.
Until they,
So why should our listeners care about the National Labor Relations Act or the National Labor Relations Board?
Right. So many that have a union in their organization are probably very well aware of the National Labor Relations Board because it governs a lot of union rules and contracts. A private employer still has to pay attention to it because they still make rulings that impact them as well. As I said, the 2023 rulings talked about how you can manage employees, how you can talk to employees, what you can expect of them. That went for all employers. That was not just those with a collective bargaining agreement. It was for all employers. Yeah. So we do kind of get deer in the headlight looks when our clients are like, why are you talking to me about this? I don't have a union. I get it. I know. But it still impacts Michigan law.
Yeah, that National Labor Relations Act protects an employee's ability to engage in protected activity, concerted protected activity, which in layman's terms means employees have to have the ability to talk with each other about wages, hours, and working conditions to determine whether or not they should try to organize and bring a union into the workplace, and that employers cannot have certain rules or restrictions in place that prohibit employees from having those kinds of conversations. Now, you can say they can't have them while they're on the clock, right? But to Andie's point about 2023 National Labor Relations Board rulings, which at that point were Democratic majority, which tended to sway much more in favor of an employee's rights versus the employer's rights, that board took a really expansive view around the kinds of things that employers couldn't do because it would be considered like a chilling effect on their ability to have these kinds of protected conversations. So general code of conduct language that was commonplace in handbooks, the board said that's got to come out or become much more specific. Confidentiality agreements, those need to be standalone documents, and you have to be really clear about the kinds of things that are confidential. You can't just have blanket wording that says, don't talk poorly about your coworkers, that kind of thing. So the board at the end of 2023 got real specific and started to govern, and some might say overreach, on what an employer could and couldn't do, regardless of whether the employer had a union. That didn't matter. The act applies to all employers, whether or not you have a union. If you happen to have a union, then there are a whole nother set of rules that apply to you. But the board is appointed by whoever's sitting, in the presidency seat. So that board will change, majority Democrat, majority Republican, just based in time.
Once they
terms extend,
they finish their terms.
Terms expire. Whoever's sitting in the president's seat gets to elect the next one, right? So we do sort of see a natural pendulum shift on the board, but this is an interesting angle where a president just goes in and just removes a member without any cause, or as you said, malfeasance,
and not at the end of their term,
just to try to shift that power balance. So at a minimum, there is no quorum right now on the board, so no decisions can be made. And then depending on what the Supreme Court decides on this, we'll see where that sits.
We'll see.
So we continue to watch that. That's one of the things that we're watching. The other two that I wanted to bring to your attention today are happening at the state level here in Michigan. So if you are a Michigan employer or if you have employees that are doing work in the state of Michigan, listen up. One of them has already happened. One of them is being discussed at the Senate level. So we'll see. The first that's already happened is an increase to the unemployment insurance benefit amounts, the dependent amount, and the number of weeks somebody could receive benefits. I did touch on this in 2024. This happened at the very end of 2024. This was a bill that got signed into law at the end of that legislative term. And it had an effective date of April 2nd. Actually, it didn't have immediate effective date. So then like the standard effective date is however many days out. I don't know what the math is, but it ended up being April 2nd. So as of April 2nd, any new claims that are filed, those claimants will have a maximum benefit period of up to 26 weeks. Prior to this, it was 20 weeks. Now, it used to be 26 weeks here in Michigan, and that's kind of standard across the country. The only reason Michigan pulled back from 26 weeks to 20 weeks is because we had the Great Recession of 2008, 2009, and unemployment rates went through the roof. The fund balance that pays all those unemployment claims is 100% employer funded, and the fund balance was shrinking at an alarming rate. There was concern that there wasn't going to be enough in the fund to support all of the claims being made, and so some adjustments were made to the length of the benefit amount, or excuse me, the length of weeks that somebody could receive benefits as a way to try to manage that from a financial standpoint. And it's sat that way since then. So it's been a long time coming. In terms of the actual weekly benefit amount somebody could receive, the maximum was $362. And that had been in place since 2002, which is crazy. It's a little low. It was way out of balance with our peers, the states that touch Michigan. We were out of whack there. It was definitely low. I don't think anyone has challenged the fact that this needed to be increased. I don't think anyone really challenged the fact that the benefit weeks probably should go back from 20 to 26. The question was, on the heels of COVID, where does our fund balance sit, and are we financially solvent enough to support this kind of increase right now? So I guess the legislature decided yes.
They must have.
So here we are. So the new weekly benefit maximum in 2025 is now $446 a week. That's the most somebody could get. In 2026, it's going to go up again to $530 a week, and then in 2027, $614 a week. So you see this stair step over the next 3 years. And then in 2028 and beyond, it will be tied to the consumer price index. So basically it automatically adjusted for inflation. So hopefully we never have this issue again where we set an amount and it stays stagnant for 23 years, right? I mean, that's crazy. And then we have to play this catch-up game. So it'll just automatically adjust from 2028 forward. There were some adjustments to the per dependent fee as well, but again, you really just need to know those maximum weekly amounts. Sure. And I tell you this because I do think for financial planning purposes, as you look at your costs, and I think people are still nervous about the economy and the direction of the economy. Yeah. We are seeing some reductions in force. And those folks, if they lose their job through no fault of their own, typically are eligible for unemployment benefits. And it's going to cost you more because the weekly benefit amount went up and the number of weeks they can claim it went up. So you're just, if you think that the fund can just absorb that without passing that increase along to all of you, wake up, you're dreaming. It's not going to happen. Yeah. Mm-hmm. So you'll see increases come through, if not this year, probably next. In your unemployment rates. One other note, so that extension of the weeks from 20 to 26, that's effective for all new claims filed after April 2nd. But the agency did say for any claims that were active from the start of this calendar year, so January 1st up through April 2nd, they're going to apply that new weekly maximum benefit amount to those weeks too. So the weekly amount increase is actually as of calendar year, January 1. The extension in the weeks, April 2 and beyond. So something to keep in mind. Finally, the other thing that we're watching, this is, we don't know if this is going to move, so I don't want anyone to freak out, but kind of this is something that I've talked about on past episodes. This is a kind of a revival of a set of legislative initiatives that were being discussed at certain levels within the legislature. This happens to now be taking place in the Senate. It's Senate Bill 6 and 7. And there's a resurgence here to further narrow the definition of an independent contractor here in the state of Michigan. Right now, Michigan follows the federal definition of independent contractor, which is the economic realities test, which was narrowed under the Biden administration. So we've already had a change to this in the last year and a half or so. And currently that's the test that Michigan follows, but there's some discussion happening at the state level to narrow the definition even more within the state of Michigan. And right now they're looking at the California test. It's the California ABC test is kind of the framework for what this new definition might look like. It's very restrictive. And, as you can imagine, there's been a lot of pushback. So in California, there are, and I can't remember the exact number, but like almost 100 exemptions to this very stringent ABC test already, because they put it in place and they realize, it's actually not going to work for all these different industries. The one that they're considering in Michigan initially had no exemptions back when this was sort of being played around with last legislative session. Now it's being revived. It's on the Senate floor. I don't believe there's been a vote on it yet. I don't know if it's going to go anywhere. As you can imagine, the same kind of pushback is happening here in Michigan that happened in California. And so the latest version of this bill is focusing specifically on the construction industry. But the concern is, what would stop them from doing it to all industries, right? So there's still a lot of pushback on this. The other thing that's interesting is they're tying in a few other sort of non-related employment law issues or components to this bill, as they sometimes do. And one of them is this wage transparency push. And we've heard a lot about this in the past years. And I think this idea that people should be paid fairly, right? Equal pay for equal work. And that is a law right now. But how do you know whether or not you and your coworker, who you think is an equal position to yours, are being paid equitably for the work that you do? You sort of just have to take it on trust, right? Or if your employer is sophisticated enough to have established wage bands,
Sure.
and steps and criteria, then that makes that much easier for you. Or if you're a public employer and all the salaries get published, then you can be sure. But in private employers, especially ones that don't have sophisticated compensation systems, this becomes a really murky topic.
Right.
And I think often when there's lack of clarity, the question is, am I being taken advantage of?
Well, and the assumption is you're being taken advantage of.
Unless you can prove otherwise.
From the employee is, I must not be getting paid what I should be. So
why is it such a secret? If you were doing it right and everything was fair and above board, why don't you just tell me?
Right. And why do you tell me not to talk about my wages?
Yeah, why do you tell me that? Which, by the way, great lead-in.
Hey.
Is illegal. You cannot prohibit your employees from telling others what they make.
Yep.
I know we might say it's unprofessional. In our day, it was uncouth. You just didn't do it. But it's actually illegal to try to prevent folks from speaking about their wages. Why? Because the National Labor Relations Act that we talked about right at the top of this episode governs the ability for employees to discuss wages, hours, and working conditions. And so you can't get in the way of that. So very frustrating for employers.
You can kind of recommend, I would prefer you not to talk about your wages. But you can't say you can't.
Can't.
And you can't discipline either.
Don't do that.
No,
don't try to take disciplinary action against them because they did what they had the right to do.
Mm-hmm.
That would be retaliation. So now we've got two illegal things going on. Don't do that. But this wage transparency piece is, it would allow employees to gain access to 3 years of wage information for similarly situated employees. And again, the concern here is twofold. One, if you work in a very small shop, maybe it's only Andie and I that work in the same job. So by asking for this, I inadvertently get to know exactly what Andie makes. And does that violate Andie's ability to keep that confidential if she wanted to do that, right? In a big organization, maybe that's less of a concern because it doesn't have to have Andie's name on it. It shouldn't, right? It would just say employee A, B, and C. Actually, the other area of concern here is that there may be very practical, legally valid reasons for why Andie and I could be doing the same level of position but not be paid the same.
Yeah. Well, our skills might be different.
Maybe our skills are different.
Our education could be different.
Oh, that could be different too.
Our experience, our length of service could be different.
Our performance.
I may have had a write-up and you may not have.
That's right.
Yeah.
That's right. I might have been there for 10 years.
Right. And I just got here and I want your wages.
No. You just got here so you make more than me.
Oh, perfect.
That's usually what happens.
Well,
the job market is such that when I hired in, you could get me for this, but this one over here, she's a rare breed, and so now you can't get anyone, so she's getting paid more than me.
Right.
Yeah.
Market demands
is another thing to keep in mind. I know that's not really the topic right now, but that internal parity piece, I would hate for there to be forced legislation that compels an employer to show that they're paying people fair wages for equal work. You want to be doing that own self-assessment, though. You don't want the law to have to tell you that it's the right thing to do. So internally, you should be looking at what different people make in a very similar job classification. And if there are differences, you should be able to validate justify that. And in a perfect world, you're moving toward a more structured compensation plan where you have established bands and you have a philosophy for how you place people along the band. You can explain it and educate staff and defend it so they don't assume that in the lack of information or the lack of transparency that you must be doing something wrong.
Correct.
Okay.
That will
Anything
be the assumption.
else?
I think we're good.
We're good. Okay, we're good for today. Will, are you good? You feeling okay? Will's
good.
We're good.
Will's
okay.
good. Yeah, good.
Well, with that, we will leave you. That is the June edition of HR Hot Topics with special guest Andie Creamer. Thank you so much for being here. We will be back in July, post our 30th anniversary party. High five. Well, I'll be back. Yeah. I'll be back in July. I'll be on vacation.
I'll be on vacation.
There you go. All right. Until then, folks, we'll see you next month.